ready, yeah. Lucy, I've got nothing to hold this door open with. The judge is coming.
Oh.
Okay, right. Okay.
Is that okay?
Yeah. Court rise.
Hand down judgment in the matter of West India Clee Residential Limited and East Tower Apartments Limited.
The judgment which I'm handing down has the result that the appeal will be dismissed. The parties have agreed an order whereby the appellant will pay the respondent's costs of the appeal on the standard basis in the agreed sum of £43,000, including VAT, by the 4th of August. There is an application for permission to appeal to the Supreme Court, which we have considered. Permission to appeal is refused. Thank you.
Appeal in the matter of the Commissioners for Majesty's Revenue and Customs and Professional Game Match Officials Limited. Part heard.
Good morning, Mr. Norbat. As you will have gathered, I'm afraid we're going to be without air conditioning.
Yes, my lord.
Which is, as people say nowadays, rather suboptimal. I'm very sorry about that. If you would like to remove your gowns, please, by all means, do so. And any other measures we can take. We won't stand on ceremony. But please maintain social distancing. And if at any stage you feel you need a short break or something, please just say so and we will be as accommodating as we can.
Thank you, my lord. My lord, I proposed just briefly this morning just to wrap up grounds 1 and 2 with just a few more authorities, but I will take them quite quickly.
Thank you.
Lord, first of all, can I ask you, the court to turn to tab 25 of the authorities bundle, please?
Don't have to know which volume that's in, do you? It's boring again. Never mind, we'll get there in a minute. It's
volume 2. Thank you.
Actually, it's the last one of volume 1, I think.
Sorry, which tab did you say?
25.
Sorry?
25.
Tab 25.
Yes, well, so it's at the end of my volume 1. It may not be the same for everyone else. James and Greenwich, is that the one?
That's the one. So it's the President, Ms. Justice Elias, and if I could just take you straight to paragraph 16 to 19, that is bundle pagination, page 317.
Yes.
And he says this: the authorities do not speak with one voice as to precisely what mutual obligations must be established. The relevant cases were analysed carefully by Mr. Justice Langstaff in Cotswolds Developments and Williams. As he points out, sometimes the employer's duty is said to be to offer work, sometimes to provide pay. The critical feature, it seems to us, is that the nature of the duty must involve some obligation to work, such as to locate the contract in the employment field. If there are no mutual obligations of any kind, then there is simply no contract at all. As Carmichael and National Power makes clear, if there are mutual obligations, and they relate in some way to the provision of or payment for work, which must be personally provided by the worker, there will be a contract in the employment field. And if the nature and extent of the control is sufficient, it will be a contract of employment. And so the references there to employment field are the field of employment stroke self-employment. And then 17, in short, some irreducible minimum mutual obligation is necessary to create a contract. The nature of those mutual obligations must be such as to give rise to a contract in the employment field, and the issue of control determines whether that contract is a contract of employment or not. The question whether a contract of employment exists arises in a number of situations. First, it is frequently accepted that there is a contract in place between the employer and the employee, and the only issue is whether it is a contract of employment or a contract for services. In that situation, the only issue is whether there is sufficient control so as to constitute a contract of employment. Then 19, second, other cases of which Carmichael, Clark, Nethermere are all examples, are situations where a worker does some casual work for an employer and for one reason or another it is necessary to show that there is a contract of employment in place where there is no work being performed. Plainly, there is a contract of some kind in place whilst the work is being performed, but the question which frequently arises is whether there is also a contract governing the relationship, what is variously described as an overarching umbrella or global contract, in the periods where there is no work being carried out. It is in that context that the courts have held that there must be this irreducible minimum of contractual obligation in order for a contract to be established. We don't need to worry about the third situation. That's the where you're trying to imply a contract between the individual and the end user.
That explains it very clearly, doesn't it?
It does. It's helpful to have a synoptic
Exactly.
view from obviously an acknowledged master of the field.
Having and taking into account Cotswolds. And so
Yes.
just to make clear that contrary to, so whereas the Upper Tribunal state in terms that in Cotswolds Mr. Justice Langstaff disagreed with Mr. Justice Elias and Stevenson, it is clear from this authority that Mr. Justice Elias didn't see any disagreement. And the next authority I'm going to take you to is Mr. Justice Langstaff, where he also makes that clear, that they say in his words, entirely eye to eye.
Where he says in 19, and for one reason or another, it's necessary to show there's a contract in place even when no work's done. Those one reasons or another includes what we were looking at yesterday. In other words, for purposes of getting the benefit of the various statutory regimes, you've got to show there's a continuous period of employment.
Qualifying service.
Yes.
Can I just, before I take you to Mr. Justice Langstaff, give you some more paragraphs for your note? It's tab 26. The case is James and Redcats. It's just for your note.
Sorry, I'm getting confused. What is it you're asking? This is James again.
No. So I just asked you to make a note of another James case. This one's called James and Redcats.
Sorry, it's a different
different
just
EAT
coincidental.
judgment.
Yeah.
But Mr. Justice Elias again. And I just want to give you the notes of the paragraph. It's 77 to 93.
Sorry, it's James and
Redcats. I don't ask you to turn it up.
Well, I do, because I can't understand what the second. Sorry, the other party. Red Cats. I see.
Redcats, yes. You may recall it was the in paragraph 91 of Uber yesterday, Lord Leggett referred to or quoted a paragraph from Mr. Justice Elias in James and Redcats.
Thank you.
But it's just another helpful synopsis or summary.
And which paragraph do you want?
77 to 93.
Okay.
Just obviously with time.
Yeah.
Yes, thank you.
The next case I'd ask you to turn up is tab 39.
Is that which one?
Volume 2 again, same volume.
Volume 2.
Yeah.
Thank you.
Right.
So this is a judgment of Mr. Justice Langstaff. It concerns a registrar of marriage, deaths, births, and she was held not to be an employee by the Employment Tribunal because of a lack of mutuality of obligation and an absence of control. Can I just take you quickly through the judgment? Paragraph 7 is, which is on page 504. internal page 2. And you'll see here, Mr. Justice Langstaff emphasises the need to carefully distinguish between overarching and individual contract cases. You see that in the third line. You'll see paragraph 8, he deals with the individual contract in entirely the same way as Mr. Justice Elias. The second is that they are employed under a succession of individual contracts, each of short, and it may be very short. So that's the same point that Mr. Justice Elias had picked up.
Yeah.
Duration, but in respect of which, when they work, it is plain that they are providing their work personally for pay, thereby demonstrating a mutuality of obligation between themselves and the employer at the time, provided that the contract is otherwise a contract of employment, albeit short. The question then arises whether the right to claim unfair dismissal has accrued, and that's the point.
Does it, I mean, presumably it follows, does it, that if you have a situation where what he describes there as casual employees can demonstrate that the individual contracts are contracts of employment, but although there's an overarching contract, they can't demonstrate that that is a contract of employment. I mean, I just can't work out whether that's a likely scenario, but let's assume that that is the position.
That's ground 3, but we can come on to that.
Yes, but if that's the position, then for tax purposes, I mean, or maybe other consequences, but the individual contracts are contracts of employment. But what they wouldn't be able to do is to show a continuous or qualifying period of employment, or whatever the word is, to obtain whatever statutory rights, for example, in relation to unfair dismissal.
So if I've understood your lordship correctly, you've got individual contracts of employment, an overarching contract which is not an overarching contract of employment.
Yes.
Well, in those circumstances, those are exactly the circumstances where you turn to section 212, which it comes onto in this paragraph, and unless you can satisfy the terms of section 212 to bridge the gaps,
Yes.
you would not have qualifying service
That's what I mean.
for unfair dismissal purposes.
So you could have that situation.
Yes.
You could have a situation where, I mean, what I'm trying to, I think, get clear is that the fact that the overarching contract is not a contract of employment,
Yes.
is not determinative of whether the individual contracts themselves are.
Exactly.
Yeah.
Yes, exactly. And that's why in our case, if we're right on grounds 1 and 2 in relation to the individual contract, and the Upper Tribunal are right in respect of control in relation to the individual contract, it doesn't matter whether the FDT were right or not in relation to the characterisation of the overarching contract.
I mean, that point was touched on expressly in at least some of the cases you took us to yesterday,
Yes.
if I remember rightly.
Yes.
In McMeechan, I think, for
Exactly.
one. Yes.
And that's the point they're making in all of those cases.
Well, not all, but some of them anyway. Yeah.
All of the individual contract
Yes.
cases, they are making that point. And that's why it's important not to conflate the overarching contract cases with the individual contract cases.
Yes, and I can see that because one might start with a sort of almost intuitive feeling that the natural thing is to look at the overarching contract first, and then you sort of expect the individual contracts to follow suit. But I mean, that may be the case, but there's no necessary connection. Or
And not only is it not the natural inference, as these cases show, it's quite common for it not to be
in
the...
fact, it may not be.
Yeah.
Because of this way, you have to focus on the actual period of the work-wage bargain,
Yes.
on the individual
Yes.
analysis.
And I will take you to an authority which does talk about the relevance of the overarching, of the absence or presence of overarching obligations, but it's at the third stage.
I'll need to find a flowchart almost. Anyway.
Well, but with respect,
Yes.
in a sense, it's a flows chart. It's a fairly simple one in the sense
is
of
actually, yes,
it's
yeah.
is there irreducible minimum mutuality of
If you're
obligation?
right. Mm.
Tick. Is there the sufficient framework of control? Tick. Third stage, there it's you look at all the factors in the round, and there are many factors you can take into account, and what may be significant in one case may not be in another case, and so it's at that third stage where it is in common parlance, a multifactorial
Yes.
assessment. But always bearing in mind that, as stated in ready-mix concrete, it's a negative requirement, and that's also a point that's picked up by Miss Justice Langstaff in the case of Wright. So you don't start from as it were, a standing start. It's a negative requirement. So you are looking to see whether the other terms are inconsistent with.
I mean, there is an element of circularity, of course, in that formulation. But I mean, I think that's perhaps inevitable.
But also to give the tribunal some discretion, because it's so fact specific. But it's very difficult, I think, at that third stage to be prescriptive.
I must say, I'm sort of instinctively a little troubled by the concept of it all being a question of fact. You'd think whether the contract under which you're employed is one of employment or self-employment ought to be in principle a question of law. Although, of course, it's a multifactorial assessment that goes into
I
rather like the question whether something amounts to a trade for tax purposes.
Yeah. Where the authorities have come down on that is it's a mixed question of fact and...
Well, that I can quite understand.
And there are, I think O'Kelly, there's quite a lengthy passage about, because up until O'Kelly there had been a long debate about is it a question of law or is it a question of fact. And in O'Kelly there's a long passage where the court address why it's a question of mixed fact and law. But as you'll see though, my lord, as all of these cases I'm taking you to, almost all of them involve an employment tribunal making an error of law in relation to the irreducible minimum mutuality being corrected on by the EAT. And it's a point Miss Justice Langstaff makes in Cotswolds, is that tribunals frequently misunderstand irreducible minimum mutuality obligation. And in Wright, he says tribunals frequently misunderstand control. And the way they misunderstand it is in overstating what's required.
Thank you.
Which is, of course, the error that we say the tribunal in this case has fallen into in respect of both limbs. Paragraph 9 is a helpful summary of the purpose and effect of section 212. Makes clear that section 212 is irrelevant to whether there is a contract of employment. It only arises if there is a contract of employment. And as I said yesterday, paragraph 26 of my learned friend's skeleton argument misstates the effect of section 212 in that regard. That's paragraph 26. Do you see in the second sentence, the contract, however, in both cases would need to be a contract of employment. A contract by which work is done is not necessarily a contract of employment. And you see, a contract by which work is done, that's the irreducible minimum requirement. Here again, there is a need to make careful distinctions between the cases which may be relevant. Many authorities are decided in the context of a choice presented by the parties as to whether the person providing work is self-employed or an employee. The distinction there between a contract for services or a contract of service is the critical one. And just pausing there, if you recall that the tribunal FTT's consideration of the status question in this case was not one of those cases, because PGMOL were arguing that there was no contract at all between the referee and PGMOL. And then do you see this? It is this on which the court's decision focuses. Some may be concerned with whether the agreement is one of employment at all, as where the contract is one of licensing an individual to do work on the premises, or as might be the case of a lap dancer in Stringfellows. Can I just pause there? Just to give you the paragraph references where you'll see that the tribunal got this right in the FTT got this right in 133 and 134. So before the FTT, again, just to show how the argument was run, PGMOL were relying on the Yun case and also Kwashi. And you'll see at 133 and 134, it's internal page 32 and 33 of the FTT decision. So beginning of 133, sets out the facts of Yun Cheng, or Cheng Yun, and then do you see at the end of paragraph 133, in contrast to the golf club member in Cheng Yun, competitions and clubs in this case do not instruct referees about what they want done and how. Referee services, because that would compromise the referee's independence, referee services are provided to the competitions, but that is done under the arrangement the competitions have with PGMOL. And then Kwashi concerned a lap dancer who unsuccessfully claimed for unfair dismissal. The key point in that case was that Stringfellows was not obliged to make any payment to the dancer at all. And you recall that's the key point that the Supreme Court identified in Hoover. She negotiated fees with customers and was herself charged by the club for being allowed to perform. In contrast, and as discussed further below in this case, PGMOL is obliged to pay the referees. So there is that obligation to pay in this case. So as I say, important to note that those were the cases relied upon by PGMOL before the FTT, and the FTT accepted our arguments that our case was different. But you can see how the confusion has arisen on the part of the FTT. Then do you see this? And this back to Woods. Other authorities are concerned with the nature of the arrangement between the parties under which, from time to time, a person may be called upon to provide work. This, as I have pointed out, may be either under an umbrella contract or a succession of individual contracts. Could I then ask you to go to paragraph 15, please? So you'll see the judge says, as to the second question, that's Miss Justice Langstaff, the first question was a question of statutory construction concerning registrars, with which, again, thankfully, we don't have to concern ourselves. Once the judge had determined that simply by virtue of it being a registrar, the claim was not necessarily an employee, was whether he had actually entered a contract of employment. Here, the judgment is to an extent deficient. It did not consider separately the cases in respect of an overarching or umbrella contract and distinguish them from those in respect of continuity of employment. Such a distinction is clearly made by, for instance, Mr. Justice Elias in Stevenson. He thought that without some mutuality amounting to what might be sometimes called an irreducible minimum obligation, no contract existed when considering an overarching contract. But at paragraph 13, he observed, and Mr. Justice Langstaff quotes the whole of the paragraph, and as you know, that is the bedrock, that was and remains the bedrock of our case. And importantly, the Upper Tribunal distinguished that on the basis that Mr. Justice Langstaff in Cotswolds had disagreed with it. But look what Mr. Justice Langstaff himself says in paragraph 17, and you'll recall that 13 is the terminable at will paragraph. So perhaps you see that in paragraph 13 of,
Yes.
of Stevenson. For that duration, the individual clearly undertakes work and the employer in turn undertakes to pay for the work done. This is so even if the contract is terminable on either side at will. Unless and until the power to terminate is exercised, these mutual obligations will continue to exist and will provide the fundamental obligations. And what are those mutual obligations? To work on the one hand and to be paid on the other. And far from disagreeing with it, what he says in paragraph 17, Miss Justice Langstaff says, that view was endorsed by the Appeal Tribunal in Cotswolds. So our submission below was that Mr. Justice Langstaff in Cotswolds was not disagreeing with Miss Justice Elias. And you'll see in paragraph 17, Miss Justice Elias himself says that. That view was endorsed by the Appeal Tribunal in Cotswolds, and it was noted in Prater that a succession of individual contracts for work, within each of which there was mutuality of obligation relating to the work provided and performed under the contract, could be contracts of service, despite the fact that there was no continuing or further obligation on the one party to offer more work or on the other party to accept the work. That's
and that sentence, or the end of it, despite the fact, that's the point on which the Upper Tribunal in this case thought that these couldn't be, as a result of which, couldn't be contracts of employment, isn't it? And this is what you showed us yesterday afternoon.
It wasn't just that point. It was also the point that they said that because the employer wasn't under an obligation to pay in lieu, so that they derive from the authorities.
Yes, okay. But it's offer more work or pay in lieu. But it's that
yes,
point.
Exactly. And they do that by rejecting my submission that the overarching authorities are not applicable to the individual contracts. They say they are of general application, which is why I've been rather labouring the point in the authorities, that the authorities are clear that that's what you should not do. Final paragraph, if I may, just as to how we dealt with it in this case, 37. So the problem in this case for the individual was that their grounds of appeal to the EAT didn't raise mutuality and control point. And what Mr. Justice Langstaff says in paragraph 37 is addressing the mutuality point. And this is paragraph 37, it's 5 lines down. I am and would have been prepared to hold that it would be painfully obvious that any person providing services for money as a registrar would, during the time they actually provided those services, be providing them personally under a contract with the council in the expectation of reward. There would be, to that limited extent, mutuality of obligation. In this, I see entirely eye to eye with that which Elias J. expressed in Stevenson. And so, in my submission, the authorities are entirely consistent, and they are consistent in the way that we have argued. Can I ask you please then to turn to Quashi, which is at tab 34. I'm not going to go to the facts of Quashi because, as I hope I've demonstrated from the other authorities, it's clear on what basis this case is decided. But I need to go to Quashi just because my learned friends and my learned friend have persuaded the Upper Tribunal at least that in Quashi, Lord Justice Elias himself resiled on everything, on what he said in Stevenson. Can I just take you to the head note, please? Just because that encapsulates the point. Do you see under observed at page 449?
Yes.
Do you see under observed at the, on 449 at the bottom of the first column? In Stevenson and Delphi Diesel, Mr. Justice Elias, as he then was, sought to bring some of the strands concerning mutuality together at 11 to 14. With regard to whether a contract exists at all during the period when the work is actually performed, he said that the issue whether the employed person is required to accept work if offered, or whether the employer is obliged to offer work if available is irrelevant, and that the only question then is whether there is sufficient control to give rise to a conclusion that the contractual relationship which does exist is one of a contract of service or not. In the present decision, he said that was too sweeping, as even where the work-wage relationship is established, and, so that's limb 1, and there is substantial control, limb 2, there may be other features of the relationship which will entitle the tribunal to conclude that there is no contract of employment in place even during an individual engagement. And that's the ready-mix third limb test. And you recall that in some of those earlier authorities, Mr. Justice Elias had just referred to control as being the determining factor. But clear that the qualification of what he said in Stevenson is not a qualification of what he said about the content of the required mutuality of obligation. It is simply a qualification of what he said that control was the sole determining factor. And can I just make that clear from the judgment? Paragraph 6, please. 6 identifies that various tests have been identified. 7 sets out the fact that the test most frequently adopted is ready-mix. And then do you see at 8, having quoted the relevant passages from ready-mix, this approach recognises, therefore, that the issue is not simply one of control, and that the nature of the contractual provisions may be inconsistent with the contract being a contract of services. And that is exactly the wording of limb 3. Can I just to make that good, in paragraph 7, you see 1, 2, 3 from ready-mix, limb 3, the other provisions of the contract are consistent with it being a contract of service. So clear what he is relating to, what he is referring to there. Then can I ask you to, if one goes to paragraph 10, do you see there is the discussion about mutuality of obligation? I won't ask you to read it all now. So just the first line though, an issue that arises in this case is the significance of mutuality of obligation. So he's there setting out what he understands to be that significance, and none of this will surprise you, given all the authorities we've been to already. Importantly, he's distinguishing between individual and overarching contracts. 12 sets out what he sets out Stevenson. And note, he's referring to all of the authorities that we've been covering here yesterday and this morning. Then, do you see it that just above 13, he says, whilst the fact there is no umbrella contract does not preclude the worker being employed under a contract of employment actually carrying out an engagement, the fact that a worker only works casually and intermittently for an employer may, depending on the facts, justify an inference that when he or she does work, it is to provide services as an independent contractor rather than as an employee. This was the way in which the Employment Tribunal analysed the employment status of casual workers in O'Kelly, and the Court of Appeal held that it was cogent analysis consistent with the evidence which the Employment Appeal Tribunal had been wrong to reverse. So just pausing there, the absence of mutuality outside the individual contract may, depending on the facts, be a factor at the third stage. Can I just make a point about O'Kelly? O'Kelly's a case that is important to read carefully, because there were 2 contracts in issue in O'Kelly, an overarching contract and an individual contract. And the Court of Appeal addressed those 2 contracts separately. The Court of Appeal were unanimous in saying that the tribunal were right in finding that there was no they were entitled to find that there was no mutuality of obligation in the overarching contract because of the absence of any obligation to offer and accept work. In relation to the individual contracts, the Court of Appeal was split. They were split because Lord Justice Ackner stated that the ET did not decide the individual contract point, and therefore he would have remitted that question to the ET. And important when you read Lord Justice Ackner's judgment to see that he has separate headings for the overarching and individual contract. In relation to the majority found that because there was a finding, an express finding, that the waiters were in business on own account, they clearly had decided the issue. But as I've demonstrated to you, the business on own account test is a Lim 3 question. And I've made the point already, sorry, that in our case, the FTT found as a fact that they were not in business, the referees were not in business on own account.
Which paragraph is that, please?
That is 172 and also certainly 172. 172 line 10. Yes, and also 174, that critical paragraph in 174 when they're looking at the other factors. Do you see it 174? Line just above line 35. The referees could not obviously be described to be in business on their own account.
Sorry, so paragraph 102, got that, and then what was the second one, please?
174.
74.
So you see, even though the level of integration, the hours worked, the fact that the referees could not obviously be described to be in business on their own account, and the fact that the PGMOL was their only or primary paymaster in their refereeing activities. So when they're looking at that third stage of are the factors consistent,
Yeah.
they find as a fact not in business on own account. Could I ask you, sorry, just to go back to Kwashi, just finally, paragraph 13, do you see that Lord Justice Elias sets out paragraphs 11 to 14 of Stevenson?
Yes.
Do you see it? You see it paragraph 14. He says this: on reflection, it is clear that the last sentence of paragraph 14 is too sweeping. So just pausing there, the last sentence of paragraph 14. The only question then is whether there is sufficient control to give rise to a conclusion that the contractual relationship which does exist is one of a contract of service or not. So that's what the first sentence of paragraph 14 is referring to in terms. He says control is not the only issue. Even where the work-wage relationship is established and there is substantial control, there may be other features of the relationship which will entitle the tribunal to conclude that there is no contract of employment in place, even during an individual engagement. O'Kelly and Ready-Mixed provide examples. And as I say, in O'Kelly, the Court of Appeal, in relation to the individual contract, find that the tribunal based themselves on the tribunal's express finding they were in business on own account. And we know that in Ready-Mix, I showed you yesterday, that was also Mr. Justice McKenna, who was clear in terms that in that case it was the third stage that was critical, and he found they were in business on own account. Now, apologies for labouring that, but at paragraph 46 of the Upper Tribunal's decision, you'll see that the Upper Tribunal rejected my submission that all Lord Justice Elias was doing in paragraph 14 was qualifying the last sentence of paragraph 14. It's rather odd that it's two 14s here. So they rejected my submission that all he was doing in paragraph 14 was qualifying what he said in the last sentence of 14 of Stevenson. They accepted my learned friend's submission, but in fact he was seeking to qualify all of what he'd said in paragraphs 11 to 14, and indeed paragraph 13. And the reference again, sorry, was, it's Upper Tribunal 46 to 47. And in my submission, that's an impossible reading of paragraph 14 of Lord Justice Elias. He says, even where the work-wage relationship is established, so that's mutuality, that's the limb 1, and there is substantial control, limb 2, there may be other features of the relationship which will entitle a tribunal to conclude. That's entirely consistent. And not only is my reading entirely consistent with the head note, paragraph 8 of this decision, it's also entirely consistent with His Honour Judge Richardson's reading in paragraph 31 of Drake. Do you recall it? You may recall in paragraph 31 of Drake, he also pointed out that Lord Justice Elias must have meant also that there was the third stage. That's just a reference.
But I mean, all this goes down to whether or not we're looking at in Quashie and what Mr. Justice Elias is saying there, whether we're looking at one EAT decision that's arguably out of sync with others, aren't we? I mean, we've been through a whole host of these decisions. I'm the last one to say that what Lord Justice Elias says shouldn't be looked at with the utmost respect, but you know, the Supreme Court has endorsed the RMC test as being the test, and ultimately all of this is directed to that, isn't it? It is, but the significance is, though, is the way my learned friend persuaded the Upper Tribunal to depart from what Mr. Justice Elias had said in paragraph 13 was by saying that actually he resigned from that. He went back on what he'd said in paragraph 13 of Stevenson in Quashie, so it was no longer good guidance. And you'll see in terms the Upper Tribunal accepted that submission. But I mean, wouldn't that just, if that's right, wouldn't that just put him at odds with Mr. Justice Langstaff? Exactly. So we would just have to, insofar as we needed to, decide which of those two views was right.
Yes, but as I hope I've demonstrated.
But neither of them is in fact binding on us.
No. But, I mean, arguably, to the extent that if you accept my submission that he is not resigning from what he said in paragraph 13, this is binding on you. My lords, can I move on to the ground 3?
Yeah.
So, could I ask you to take up the FTT decision, please? What I propose to do is to start this one the other way around with the FTT decision, so that you can see the context where I'm heading. First of all, let's start with the conclusion on the overarching contract. That is at paragraph 151. And as I say, I start...
Sorry, I'm not with you.
Sorry, paragraph 151, it's page 37 of the FTT decision.
Oh, FTT, right.
We're still on your grounds 1 and 2, are we?
No, my lord. I'm starting ground 3.
You're now on ground 3, I see.
So this is the conclusion on whether or not there was an overarching contract of employment. And you see in this conclusion, it's at paragraph 151, it follows that whilst there were overarching contracts between PGMOL and national group referees in respect of each season, so just pausing there, FTT rejected the argument no contract. Those contracts were not themselves contracts of service because there was no mutuality of obligation outside the individual engagements. So again, implicit in that is that there was mutuality of obligation inside the individual engagements. Then this, C, and you see the authorities they cite, Eustech, Stevedoring, Carmichael, Clark, all overarching contract cases. Of course, here we are looking at overarching contract. But just pausing there, it is important that in each of Stevedoring, Carmichael and Clark, the individuals were casual workers for whose services the demand was unpredictable, and therefore the engager wanted flexibility and was willing and intended not to have their relationship regulated by contract when the casuals were not working. So what the tribunal doesn't pick up on, and in each of those cases, it's because there was an express provision providing no obligation to provide work, no obligation to accept work. The Court of Appeal found no overarching contract at all of employment or anything else. And what the tribunal don't pick up on or seem to take any significance of is the fact that they are finding that there is a contract with mutual obligations. Otherwise, it wouldn't be a contract. So I just put that in as the context. Could I ask you, so that's their conclusion. There is an overarching contract for the season, but they say there is no mutuality of obligation outside the individual engagements. Now, I think what they must mean is the work wage bargain. Now, why do they say no work wage bargain? If we start at the beginning of that section, you'll see it starts at page 35 and it's paragraph 145.
But I mean, what they're setting out in 151 is their conclusion, isn't it, from all the previous paragraphs where they've analysed the overarching contract.
So I'm now. I just wanted to start with what did they conclude, and now I'm taking you to the beginning of that section.
All right. So sorry, I didn't catch which paragraph you want to go to now.
Paragraph 145.
145.
And do you see it's overarching contract, other terms. 145, they say, Mr. Norbat sought to argue that the reality of the arrangements meant that there was some legal obligation to provide work or accept work offered. We disagree. The terms of the Code of Practice are clear that there was no such obligation, and we do not think that this is overridden by the parties' conduct, the practical realities, or in auto-cleanse terms, the true intentions of the parties. So just pausing there, they say that the terms of the Code of Practice are clear that there was no such obligation. And they say, and they don't think that that's overridden by the other circumstances. So I'd like to start with that premise about the Code of Practice being clear. Can I ask you first before taking you to the Code of Practice, I want to take you to the findings of fact in relation to the Code of Practice, and the contract. Can we start with 141, please? So this is the overarching contract written terms. They say that the code of practice and the covering email amount to a written offer to include the referee on the national group list for the relevant season. And the referee accepts by signing and returning the code of practice. So that's the offer and acceptance. They then identify the written terms in sense of legal rights and obligations of the parties can be found in various places, and they identify the code of practice, the fitness protocol, declaration of interest form, the merit payment document, and the code of conduct. We also consider that some additional terms are supplied by the match day procedures. That will be relevant when we come to the control point, because that sets out the instructions for how you conduct what they should do on match day, and that's contractual, which we have found to exist to provide protection to PGMOL as well as the referees and competitions. So this overarching contract covers not just the gaps, it covers the match day as well. 142, this is important. Although much of the documentation is written in terms of expectation rather than legal obligation, there are some provisions that we consider amount to legally enforceable rights and obligations. So they dismiss, in one sentence, the provisions of the code of practice that are characterised as expectations. And they identify in this paragraph the consideration going on either side. From PGMOL's perspective, it agrees to include the referee on the list, to provide a system of continual assessment and feedback along the lines indicated by the match assessor guidelines, to provide a training programme and a coaching system, and to provide match kit, health insurance and access to sports scientists. From the referee's perspective, so this is the consideration that they identify going the other way. They agree to act impartially. Well, presumably that's on match day. So immediately one's thinking we're getting into work related. To declare conflicting interests and to decline to act and declare gifts over a certain limit. They also agree not to enter into sponsorship or promotion arrangements or undertake media work except as permitted. In the fitness protocol, whilst passing the fitness test is a qualification to join or remain on the list rather than an obligation on referees, PGMOL clearly undertakes to provide the opportunity for referees to be tested and reserves the right to require a retest. So they've switched back onto PGMOL's obligations. So what you saw in those last 4 lines is the sum total of the referee's obligations, the consideration they've identified in respect for all of the onerous obligations that PGMOL are carrying out. As regards training, the document is largely in terms of recommendation or expectation, but there is an obligation on referees to inform their sports scientists immediately about injury and keep them updated about that. So that's an obligation. The code of practice also contains an obligation to attend meetings with coaches. The merit payment document is also written in terms of legal entitlement. This is important. So you've got a merit payment document because it goes directly to pay. The merit payment document is also written in terms of legal entitlement, providing a relatively clear formula for the distribution of the available amount. It has a clear link to the merit table and therefore to the match assessor's guidelines. Then the match day procedures, again, will be relevant to control. The match day procedures document contains a number of obligations, for example, about arrival time at grounds, turning off phones, behaving appropriately, and reporting possible threats to integrity. The Code of Conduct also places obligations. Then this, whilst this code largely reflects obligations that referees owe the FA in any event, and the match day procedures largely reflect competition requirements, they do amount to specific commitments to PGMOL. So just pausing there, when we come to the overarching contract, sorry, the control point, this will be important because what this shows is as between engager and individual, in the contract, in the contractual documentation, PGMOL, the tribunal find, are reserving to themselves the right of control by requiring these specific commitments in relation to the individual match, engagement, contractual commitments to them. And it's only because the tribunal focused on whether or not PGMOL could haul a referee off in the middle of a match that they ignored, that they found, one, that there wasn't a sufficient framework of control. Can I ask you please then to turn back to FTT 60?
But I mean, we're looking, aren't we, at the moment, to, I mean, we're looking to see the basis of their finding in 145 that there was no obligation to provide work.
Yeah, and
I mean, control, the fact that they have certain rights of control is not inconsistent with there being no obligation to provide work.
Sorry, I was just in the interest of time, to avoid me having to come back when I come back on control, as I was on the paragraph, just trying to deal with it quickly by...
Yeah.
Yeah, no, I understand that. So we mentally decide that, put that in the margin for the moment. Remember it, or try to remember it when you get onto control.
I'd be very grateful.
Yeah.
Could I then ask you please to turn back to paragraph 60, FTT paragraph 60. So here you have referees, including select group referees, that PGMOL proposes to appoint to the national list, are then sent by email, a number of documents, some of which require signature. This is the pre-season email. Then you have at 61, the Code of Practice. So these are the FTT's findings about the Code of Practice. And I'm deliberately taking you to these findings first, before I take you to the Code of Practice. And you recall it's the FTT's construction of the Code of Practice, which is the basis for saying there was no obligation. 61, this document refers to the invitation made to join the list and states that if the invitation is accepted, then you're not an employee of PGMOL and will be treated as being self-employed. It goes on to say that match officials who have accepted an appointment to the list will be expected, so there's the first expected, will be expected to adhere to the Code of Practice outlined below. The document requires signature and returned by the referee, who by signing confirms. So there's the declaration. I'm pleased to accept the invitation to join the PGMOL list for the season 15-16 on the terms outlined above and in the fitness protocol. Paragraph 62. The content of the document is relatively brief and deals with topics under a number of subheadings. Under appointments, it is stated that the appointments will be made by PGMOL and that there is, and this is the clause that the FTT bases itself on, no guarantee that match officials on the list will be offered any appointments to matches. Match officials are not obliged to accept any appointments to matches offered to them. Then this, paragraph 63, a number of points are listed under, and they put in inverted commas the heading, expectations. All introduced by the words match officials shall be expected to, and then it says the points covered are being readily and regularly available for appointments to matches, reaching and maintaining a satisfactory level of fitness as determined by PGMOL, undergo fitness testing and any other assessments in concordance with the fitness protocol. This, observing and obeying the FA and competition rules and regulations, and carrying out all instructions, procedures and directives relating to match officials issued by PGMOL. It states that sanctions related to breaches will be carried out only under those procedures. Under conflicts of interest, it sets out the points about conflict of interest. 40 is points about sponsorship. 65 talks about continuous monitoring.
Mr. Norbert, I'm terribly sorry to interrupt you. I've just had a message passed to me, which I'm afraid I need to bring to everyone's attention. It comes from the senior operations manager in the building and effectively contradicts the permission which I gave earlier for people to take off their masks unless those who are actually speaking. I'm told it is still HMCTS policy that however hot and uncomfortable we may be, everyone should still keep their masks on unless they are actually in the course of addressing us. I hope you will appreciate that that is a statement of HMCTS policy, and I feel obliged to pass that on in the expectation that it will be adhered to. I'm very sorry about that, but thank you. I can see you are all putting your masks on, except for those speaking and the members of the court. I think we are allowed to remain unmasked. I just reiterate the point that if this does cause intolerable discomfort, please don't hesitate to ask for a short break at any moment, and if it felt to be helpful. But there we are.
Thank you, my lord. So my lord, I was just going through the paragraph. So 64.
Yes.
Lord, you'd got the point around 63. Is the expectation point that they note that a number of points are listed under expectations, and you see what those are. Then 65, the requirements. Then PGMOL guidelines. This is a relatively lengthy document produced by Mr. Riley, described as containing directives issued by PGMOL for the relevant season. And you recall that the word directives there picks up the code of practice, the expectation that you'll be all instructions, procedures, and directives relating to match officials issued by PGMOL. And you'll see that those guidelines are about the conduct of the game.
Yes.
Then you've got your match day procedures. And you see at the bottom line, there is an instruction to behave appropriately at all times and do nothing. Remember, the match day procedures are themselves contractual. And then do you see the last sentence, that the procedures provide protection to PGMOL, as is clear from the covering emails. And those covering emails, the other ones are, you've got the declaration of interest forms, you've got the fitness test as well. I won't go through the rest of those paragraphs. Can I just take you to the covering emails before we go to the code of practice? That's at FTT 82. Because recall, the tribunal found, as I've shown you, that the covering emails constituted part of the offer and acceptance. So when you're construing the code of practice, you have to construe it with the emails which are part of the contractual documentation.
Yeah.
And paragraph 82 says this: the 2015-16 email refers to the code of practice as setting out the basis of your relationship with PGMOL. Importantly, the 14-15 equivalent states that the code sets out PGMOL's requirements of you. So just pausing there. So the offer tells you that the code of practice sets out PGMOL's requirements of you. So when you are reading the code of practice, that's the context in which you're reading it, as well as the declarations. So can I ask you to now turn to this code of practice? So that is in your supplemental bundle.
I guess let's be careful with words like requirement.
Sorry?
I mean, words like requirements, I mean, sometimes it means legal obligation, sometimes it means something falling short of a legal obligation. Rather topical in the context of masks, as it happens. But
you said something about expectation, and
yes.
I was going to make a flippant joke, but I restrained myself.
We must all try to restrain ourselves. But the point is that the precise nuance of these terms is very much surely a matter for the tribunal of fact, which has heard all the evidence.
The problem is as I've shown you in those paragraphs, there is no indication that in construing the code of conduct, the tribunal did anything other than identify that the heading and the label was expectations. So in those paragraphs, I showed you in.
And we'll come to that, but surely we can credit them with understanding that a word like expectation, I mean, the precise nuance will depend on the context.
Well, when we go to the code of practice, if I can show you the document.
Yeah, of course. Yes.
In my submission, when one looks at the document, I'm afraid in my submission we can't credit them.
But this isn't a challenge to their findings of fact as regarded. I mean, we've already made comments about whether it is a factual, but
that was why I took you to Byrne Brothers yesterday. Do you recall the passage in the two paragraphs in Byrne Brothers where, first of all, Mr. Justice Stevenson Mr. Recorder Underhill identified that in Stevenson the contract didn't just consist of the written contractual documentation, the terms which we found in all the facts, but said that the construction of the contractual documentation, the written contractual documentations, was a question of law.
well, your ground of appeal doesn't take that point. Your ground of appeal says they either failed to take into account relevant matters, or they took into account irrelevant matters, or their finding was perverse.
Well, in my submission, it was perverse because they clearly misdirected themselves in law.
So your ground of appeal doesn't spell out all the particulars that need to be given for a challenge of that nature.
Well, certainly the grounds of appeal on which permission was granted wasn't just the grounds. It set out the basis of those grounds, and it certainly included that point.
We got that document in one of our bundles somewhere.
I believe you do. It's in your core bundle. Um, 121. Perhaps we go to that.
Sorry, is this page 121?
Page 121.
Yes. Of course, you were given permission by the Upper Tribunal, weren't you?
Yes,
Yes.
well, yes.
Yes.
It's paragraph 30. Yeah. And you'll see paragraph 32 makes the question of law. So ground 3.
Well, that with respect is just as generalised, isn't it? I mean, you take the point there that the construction of the contractual documents as
Yes.
written terms is a question of law, but
sorry, in paragraph 25, we say it based this erroneous conclusion on the statement in the Code of Practice. In reaching this conclusion, the FTT and Upper Tribunal, in failing to overturn it, misdirected themselves in law, failed to take into account relevant considerations, and/or reached a conclusion which was perverse. Raised an important point about the work-related obligations.
right. So, what are you saying, that they misconstrued the words "there is no guarantee," etc.?
But if I can go to the Code of Practice, I can show you. That's what I was going to show you exactly. But the important point is that as I submitted below, the misdirection is that in construing that clause, they failed to take into account the other provisions in that document.
Well, that's another point. But I must say, I'm speaking for myself, I'm by no means convinced that Byrne is correct if it really purports to say that the construction of a written document is entirely a question of law, even where the relevant contract is not confined to a written document. I mean, my understanding is that it's only, I emphasize only, where the entire contract is contained in a written document, that the construction of that document is a pure question of law. In all other cases, including ones where you have written documents which are part of the contract, you have to look at the whole situation, and you're not, it's completely wrong to say that the documentary bit of the evidence has to be put into a little cocoon all of its own.
Sorry, I'm not for one moment suggesting that you can't take into account the broader context. I mean, I'm the one who relies on Wood and Capita,
Yes.
For the and how you construe that.
Well,
clause.
sorry, that's another
But-
point. That's
but-
how you construe a written document in the light of the surrounding circumstances. But this is a separate question, which is whether the contract of employment is entirely contained in a single
sorry,
document.
No, but that's no part of my submission.
That's just what you were saying. You were
No,
saying
no.
we have to construe these.
No, sorry, no, I'm not.
Right.
It's no part of my submission that all of the terms are found in the written documentation. My submission is that the tribunal have found that there is no obligation on the basis of its construction of the code of practice.
Well,
And,
why
that,
not?
and if it is erred in its construction of the code of practice, that is an error of law.
But I mean, this maybe get a little bit circular here. I mean, you're treating. It sounds to me as though that formulation treats the question of construction of the, whatever they're called, the terms, as though that were a sort of hermetic aspect of the contract, which has to be,
Well,
which there is only one correct construction as a matter of law.
but with respect, and that's why the point with respect that you enlightened on about, well, have they just focused on the label, is quite important, because when one looks at the, can I take you to please to the code of practice?
Yes.
Um,
Where do we find that?
so
I'm
that's
sorry, I
in
know
the
it's in the
supplementary bundle. It's page 90. Tab 8.
Yes.
So you see from this document that the heading is it applies to the select group assistant referees. So those are the assistant referees for the Premier League.
Yeah.
National group referees. So those are the ones who referee the championship, primarily the championship, Leagues 1 and League 2.
So sorry, they're the ones we're concerned with. Is that right?
Yes,
National
that's
group.
right.
Yes.
So they're the fourth officials in the Premier League, referee the championship and the Leagues 1 and League 2,
Yes.
and also the national group assistant referees.
Yeah.
But we're just concerned with the national group referees.
Yes. Thank you.
In your capacity as a qualified referee, you have been invited to join the professional game match officials list for 14-15. If you accept the invitation, then as a match official onto the list, you are not an employee of PGMOL and will be treated as being self-employed. So your first, this is first sign is drafted by lawyers. So it's standard terms. This isn't two commercial organisations entering into a contract. It's the classic employment field relationship.
Well, it doesn't mean that the words can just simply be ignored.
No, but it does mean in the employment context, and this may need to come to auto cleanse, where they say that the normal rules of construction to normal contracts don't apply to contracts in the employment field, because one has to take into account that they are drafted by the armies of lawyers who are trying to achieve a specific purpose.
So what, you then look at the way the parties have actually operated them?
No, with respect, you in construing the terms, you view the terms realistically. And so if we then go...
So if it says you're not an employee, you read it as meaning you are one, do you?
No, you did... Sorry.
Isn't it a bit like the lease license?
Exactly,
case,
Street
where
and
you
Mount,
have
but it's exactly
a written
that.
document that says this is a license, but actually you look at the terms and you think
Yes.
no way.
Exactly. I mean, Lord Justice Henderson in an employment status case himself made the point that the labels the parties put in this area, status area, the labels the parties put on the contract has I think you said marginal relevance.
Well, I think that maybe even that. I think it's wrong to say it's irrelevant. I mean, the fact that the parties have signed up to an agreement on a particular basis
But with
without
respect-
any.
But with respect, I did not say it was irrelevant.
All right. Yeah.
It's not decisive.
It's not certainly not decisive,
No.
and one tends to be a little bit suspicious when
Exactly.
you see it in a document like this as
Exactly.
expressing a hope of what the correct outcome in law might be.
And that was the only point I was making.
Well, in the lease license cases, you can call it a license, but if in fact it gives you exclusive possession, it's a tenancy.
Except in
so-
certain tax cases, which I won't.
But I mean, I follow that. Labels in that sense can't be determinative. You look at the substance of the arrangements between the parties.
Yes.
But that's what they're doing here. They're not relying on labels, so to speak. I mean, they're looking at the sentence. There's no guarantee there.
That's my point, though, is they are looking at that sentence in isolation, and so that's why I want to take you to the whole document. I've taken you to the email that they're sent. The next one, match officials who have accepted an appointment to the list will be expected to adhere to the code of practice outlined below. That's everything below. And remember, this is an offer. This constitutes the offer that is signed at the end. Appointments. Appointments to matches will be made by the Professional Game Match Officials Limited. And it's that last sentence. There is no guarantee that match officials on the list will be offered any appointments to matches, and match officials are not obliged to accept any appointments to matches offered to them. Again, standard clause that one sees, as you've seen in all the cases we've looked at before. Then this, the first substantive heading is the requirements of the referee. So, expectations. Match officials shall be expected to be readily and regularly available for appointment to matches by the Professional Game Match Officials Limited. And as I'll show you when we go to Pimlico Plumbers, that has the no obligation clause and has other clauses, Court of Appeal clearly you've got to construe them together. And the Court of Appeal say in respect of that clause we just looked at about the no guarantee, it can't mean that they're signing up to make themselves not available to accept any matches the whole season. Because in these cases, all you have to show is there is some obligation. So the first one, match officials shall be expected to be regularly and readily available for appointment to matches by the Professional Game Match Officials Limited. In my submission, clearly, that is a contractual obligation. 2, reach and maintain a satisfactory level of fitness. 3, observe and obey the rules and regulations. 4, carry out all instructions, procedures and directives relating to match officials. 5, observe the rule, and I say that's an important one. 5, observe the rules and regulations of the FA competitions. 6, abide by the FA regulations. Then you have some additional points for assistant referees that we don't need to trouble ourselves with. So that's the first main part of this document. You then come on to other headings. Conflicts of interest, fees, expenses, marketing and public relations activities. So there you're looking at PGMOL's, at the PGMOL obligations, that side of it. You've then got the match officials appraisal. And so here you find all of PGMOL's obligations, the consideration that PGMOL is providing under this contract. Then you get to training. So under match officials appraisal, you see where you get the continuous monitoring of match officials' performance will be undertaken, with individual appraisals being made when appropriate. They find that's a contractual obligation. Training, PGMOL.
So the FTC found that was a contractual obligation.
Yes, because it's not under a head. So they find the contractual obligations buried in these other subheadings because they haven't got expectations above them.
Well, it's also because you do find the language of contractual binding force, like guarantee, I'm obliged to. I mean, those are terms which do normally import a legally binding obligation, whereas expectation is ambiguous. It may or may not.
Well, that's the point. It's ambiguous. It may or may not. So that's why the context is important. The whole document is important. And why one would expect in a decision that dismisses them as having no legal obligation, there to be some analysis as to why not. And so then you get to fees, expenses, math training, uniforms, health insurance, and then you get to, I'm pleased to accept the invitation to join the list on the terms outlined above.
Yeah.
So what is it? What is the consideration that the referee is providing under this contract for the onerous obligations that go the other side? it must be these bullet points that are there under the expectations. This is a contract for the referee to be on the list for the season.
You've got to be to get on the list. You've got to agree to abide by the fitness requirements, and if you're given a match, all the other requirements that apply when you're refereeing or after the match. All those sort of points that are set out here. Some seem to govern the position while the referee is available, if you like, on the list. Others apply if he's actually chosen to referee a match.
But with respect, where you've got a term in the agreement, this is which says be readily and regularly available for appointment to matches over the course of the season. Can it really be the case that when signing this up, it's your expectation that actually you are under no obligation to make yourself readily...
I understand that, Mr. Noel, but what I'm not clear is, I mean, you accept there's no express obligation in this or any other document which imposes on the organisation an obligation to provide the referees with work.
So, just pausing there, if I may, important to remember in the context of the obligation on the employer, as we saw in Cotswolds, and I can take you to that point, but it's referred to in the others. Actually, in this context, you don't need for the work wage bargain in an overarching contract for there to be an obligation to provide. Ms. Justice Langstaff says that can be broader, but I'll take you to that. But in this context, the key point is that and the authorities are also clear on this, if there is an obligation on the referee to make himself readily and regularly available for appointments, the corollary of that must be an obligation on the engager to at least consider him for and to provide him with a reasonable amount of matches. I will take you to those.
So what is this? Is this an implied term arising out of the express terms, or is this a term based on conduct or something of that?
So an express term that the referee must be readily and regularly available, and it must be an implied term that is the corollary of that express term. But I say it is that express term. And there's the other point that the requirement to be readily and regularly available means that where it says in the guarantee part, where it says that you're not obliged to accept any appointments, that cannot mean any appointments at all. It's any particular appointment. And you'll see that's the way the Master of the Rolls construed a similar provision in Pimlico Plumbers. Can it be that these referees sign up to these terms and conditions with no obligation to make themselves available for any match over the course of the season? Because that must be the construction of the... in order for there to be the insufficient obligation on the part of the referee, that must be the construction. That a referee can sign up to these terms and conditions, knowing the expense that is going to be incurred by PGMOL, and they are under no obligation to make themselves available for any match.
But isn't the FTT's answer to this that in many contexts that argument would be compelling, but in this particular context it isn't, because we're dealing with an incredibly highly motivated cadre of amateurs, in the best sense of the word, who really want to be referees in their spare time and go to enormous trouble to make themselves fit and able to do that. And they want to referee as much as they reasonably can during the season, so there's simply no need for a contractual obligation.
In which case, and that's the important point about contrasting it with the Carmichael, Stevedore cases, where and Carmichael, where Lord Irvine says expressly that the parties in that case chose not to regulate their relationship outside the individual engagements out with a contract. So no contract. And that's the importance of distinguishing it. This case, they do. They insist on a contract.
Yes, but
you see the covering email where they say what they require, And then when you look at the document,
Yes.
if they didn't insist on it, why is it in here? Why is it here on the first page of this document?
Well, because it's making clear a non-contractual obligation, which everyone understands will be taken seriously and will be almost certainly complied with, but lacks contractual force. I mean, that is a possible. Why is that not a possible conclusion for the tribunal of fact to reach?
But with respect, in an employment field context, where you are looking at, and that's where we may well have to come to autoclaims. But in this area,
Yeah.
That is how you would approach a normal commercial contract.
Yes, but this isn't.
This
isn't a normal commercial contract.
Exactly, and which is why that approach is inappropriate.
Yes, but you're trying to re-argue here for the second time on a second appeal what is, as my lord said, essentially on the particular point you're on, a question of fact.
Well,
I mean, you can't get the term you want out of the express words of the document. If you want to try and get it out of implied or on the basis of looking at the sort of general factual contents, all that is dependent on the tribunal's findings of fact, which are case specific. It doesn't help us to look at other cases where the facts were different.
But with respect, in circumstances where the tribunal have adopted a very literal approach, where they base it on that one clause, they don't consider, for example, at any stage what is the impact of that no obligation clause of the be readily and regularly available clause. That's why. Can I take you please to Pimlico Palmers just to see how the Master of the Rolls puts it?
Yes.
Are you going to develop a point which I think you were making a minute or two ago, along the lines that...
Sorry, my lady, you're
I'm sorry, we are being intolerably tried today with noises off as well as everything else.
I'm sorry. Are you going to develop in a moment the point you made a minute or two ago, which as I understood it was, even if there isn't an obligation to provide or to accept work during imposed by the overarching contract may nonetheless contain obligations which are consistent with the contract of employment, such that it is a contract of employment, even though there isn't that obligation.
So yes, but I must make it clear that that's on the part of the employer.
Yeah.
Yes, absolutely.
Okay. Well,
So
I've understood that.
Yes, absolutely.
Okay. So Pimlico.
Yes. Pimlico, please.
Yes, so where are we going to find?
So that is in your authorities bundle, and it is tab 41, which is in your bundle. We'll get there in a moment.
It's in bundle 2.
Two.
Yes, thank you. Well, at least we can hear ourselves talk now. That's famous last words.
I was going to say, let's not speak too soon.
Right. Sorry, which tab is it again, please?
So it is tab 41, please.
My fault for not paying attention. Thank you.
And so as I say, and you'll see as we go to Pimlico, just to make clear my submission, I'm saying I do say that the obligation on the worker to make themselves readily and regularly available is an express term of the contract, properly construed. So in Pimlico, just if one looks at paragraph 6 to 10, you'll see that there was a 2005 agreement and a handbook, which is 8, sets out the manual and has working times at 10. Normal working hours consist of a 5-day week in which you should complete a minimum of 40 hours. Adequate notice must be given to complete. To the control room for leave, etc. And then at paragraph 26, you'll see in 2009 a new contract was entered into. And you will see paragraph 26 is the critical clause that they had to construe. And do you see the fourth line? For the avoidance of doubt, the company shall be under no obligation to offer you work, and you shall be under no obligation to accept such work from the company.
Sorry, my fault again. Which paragraph?
Sorry, 26.
26. Sorry, no, I wrote it down wrong. Thank you.
So very similar to the clause in our case. So fourth line of paragraph 26. And then paragraph, paragraph 42 gives you is the relevant finding on about the ability to reject jobs, and that's the third line. Mr. Smith could reject particular jobs taking into account, for example, the nature of the job, how far he'd have to travel, also make a decision about when to go home in a working day, decide his own working hours. Agreed the company had no obligation to provide him with work on any particular day, and if there was not enough work, the company would not have to provide him with work and he would not be paid. Then do you see at paragraph 96? You'll see Mr. Linden advanced a raft of criticisms of those observations of the tribunal. They can be briefly summarised in no particular order as follows. First, he said that any finding that Mr. Smith was obliged to work any particular or minimum number of hours was inconsistent with the express provision in paragraph 2.2 of the 2009 agreement that, for the avoidance of doubt, the company shall be under no obligation to offer you work, and you shall be under no obligation to accept such work from the company. You'll see at 99, we relied on the fact there was no scope for any implied term as to minimum working hours based upon actual working practice not being consistent with the express terms of the 2009 agreement. On this point, we refer to stevedoring and haulage services, in which the Court of Appeal held that contrary to the decision of the Employment Tribunal, the applicant dockers were not employees but were working under a series of individual engagements. This is paragraph 99. Mr. Justice Tuckey, giving the judgment of the court, said, if there was a contract, we cannot see any way in which the tribunal's implied terms could be incorporated into it. The implied terms flatly contradict the express terms contained in the documents. A positive implied obligation to offer and accept a reasonable amount of casual work cannot be reconciled with express terms that neither party is obliged to offer or accept any casual work. None of the conventional routes for the implication of contractual terms will work. Neither business efficacy nor necessity require the implication of implied terms, which are entirely inconsistent with the supposed contract's express terms. So in Pimlico, we relied on the fact that 2.2 was an express term, and that you couldn't imply a term. You then look at 105. For all those reasons, Mr. Linden Smith, this is not a case in which Mr. Smith and the operatives worked under an overarching or umbrella contract rather than a series of separate engagements. He argued it was similar to the situation in Carmichael and stevedoring. So the argument here is, was there an overarching contract? Then do you see at 111 how the Master of the Rolls deals with it? Provision in paragraph 2.2 of the 2009 agreement that Mr. Smith was not under any obligation to accept work, interpreted in the light of practical reality, was also not inconsistent with the manual's contractual obligation to work a minimum 40-hour week. Then this. It meant that Mr. Smith was free to refuse any particular work assignment or any particular date, but not that he could refuse all assignments. That would make no sense at all from either side's perspective.
Sorry, where are you reading from now?
Paragraph 111.
Yeah. 1-1.
So how
Yep.
the Master of the Roll says 2.2, the equivalent of our clause should be correctly construed.
Yeah. But I mean, they were trying here to reconcile what on the findings was an operative manual which provided for a normal working week of 5 days and 40 hours with the provisions that you've shown us. And that on one view it was said that they were inconsistent, and the question was which governed, but what the Court of Appeal is saying is that they weren't necessarily inconsistent. They could be interpreted, the two of them, as consistent with each other.
But with respect, he goes further than that. He is there construing the same clause as us, and for the tribunal to be right, the clause in our case that you've looked at must mean that the referees were available not just to refuse any particular engagement. Over the course of the season, they could refuse any engagement. They entitled to refuse any engagements.
Well, where's your equivalent in this case of the manual?
Well, sorry, with respect, there are 2 points to that. One is, it's not even in a separate document. You've got to be regularly and readily available. So you've got to interpret it, whether it's labelled expectations or anything else, you have to interpret that no obligation clause in the context of what immediately follows. And two, as in that case, it would make no sense at all from either side, either the PGMOL side or the referee side, that they were under an obligation, that they could refuse refuse all assignments over the course of the season.
This noise is really reaching an intolerable level. I'm really wondering whether we can continue with the hearing in these conditions. I'm terribly sorry, but I think at that level, it's really pretty much impossible for anyone to concentrate properly.
Is it possible to find out where it's coming from?
I can't work out where it's coming from and whether any steps can be taken to try and get it. I mean, if it's actually in our yard outside, one hopes the authorities. I know. I mean, the normal rule when building works are taking place nearby is that they are suspended, or at least really noisy machinery like that is not allowed to operate during normal court sitting hours. And here we are, 12 o'clock in the very middle of the day. It produces a completely intolerable situation for everybody concerned, and I just think justice can't be done if we carry on with that level of interference. So, and I think what I'm going to propose with the greatest reluctance is that we probably break off now and we see if an attempt can be made to remove that level of noise interference before we resume. Otherwise, we're going to find every 10 minutes. I mean, it's an intolerable problem for, I think, not only for, well, certainly for you, and definitely for us to try and do justice to what you're submitting to us.
Although perhaps another alternative, if we moved further up the building, if there was a court-free...
Well, I doubt there'll be a large enough court-free. I mean, you mean further up in the sense of... courts this size are all on top of each other, so I think, if anything, I don't think the position would be any better. But well, of course, it's now stopped. Now I've made that.
Can't you send a message to someone to go out there and tell them to stop? Yeah.
If you wouldn't mind, could you perhaps? I mean, we've been getting instructions from Sarah Christo. Maybe she's the person who ought to be dealing with this.
Accommodation. I can call them.
Well, now that calm has broken out again, shall we see if we can continue? But if it's another outbreak like the one we've just had, I just don't see any alternative, I'm afraid.
Might be, if it does.
We could have an early lunch, so to speak.
I was going to say,
Yes.
might that be the answer if it does?
If we have a recurrence, I will suggest we have our lunch. We will have our hours break early.
Maybe Sir Nicholas could go outside and have a word. I suspect that would put a stop to it.
Sorry, but as we were,
Back,
Mr. Morvat.
we're back on this paragraph 111.
Yes.
But in my submission, it is an important paragraph because that must be the tribunal's construction.
Well, it was in that case, but I mean, every case is different.
No, I'm talking about in our case.
I'm sorry, in our
case.
Yeah.
But they don't say that in terms. They don't really address this. They don't address the logical conclusion of their submission, that they could refuse all assignments. And this is in context of where, if one looks at their findings, I haven't...
Well, I'm sorry, I think they do show. I mean, somewhere they say there was no need for contractual obligation because of the self-motivation of the people involved.
Well, but
why does that not address the point?
But with respect, I mean, that point is addressed in Laing, which is the... can I just briefly take you to Laing before going back to the decision? That is in tab 49.
I'm sorry, I'm talking about this case, not about other cases.
No, I understand, but before I come back to the facts,
All
I
right,
just want to take you
sorry, yeah.
to Laing.
Laing, 49. Is there any more we want us to get from Pimlico Plumbers before we leave it?
Can I just ask you for your note? Yes. Yes, can I just do it very briefly? Sorry. Paragraph 140, please.
Yes.
As for Mr. Lynn's reliance on paragraph 39 of the reasons, I start by noting that what the judge there held reflected the reality of the obligation between parties was not that Mr. Smith was under no obligation to work a minimum number of hours, but that the company was under no obligation to provide work. Analytically, the two questions are separate. In theory, Mr. Smith might be under an obligation to do whatever work the company provided without the company being under any reciprocal obligation to provide work, even if available. In practice, of course, that is not likely to have been the mutual understanding, particularly, where Mr. Smith was obliged to incur the cost of hiring a company van and was also subject to the restrictive covenants. I think that all the judge intended to hold at paragraph 39, which is also all that I would have expected Mr. Smith to have intended to accept in his evidence, was that the company was not under an obligation to provide work when none was available. That too may not be the natural reading of clause 2.2 of the 09 agreement if taken in isolation, but it was one which was open to her on the basis of trying to make sense of the totality of the contractual materials. So just how you can analyse the two obligations separately. Then just very briefly at 145, please. And again, apologies, I'm just dipping back into grounds 1 and 2 just for this paragraph. You'll see just Underhill addresses mutuality of obligation again. And it's just convenient because he picks up what he'd said in Windle. So 145. Second, although the argument before the tribunal and before us was couched in terms of whether Mr. Smith was subject to a legal obligation to work or be available for a minimum number of hours, it should not be assumed that if there had been no such obligation, the evidence about what hours he worked in practice would have been irrelevant. It is necessary to distinguish two separate circumstances in which the issue of whether a putative employee/worker is engaged on a casual basis might arise. The first is where the substantive claim directly depends on their enjoying employee-worker status in respect of their periods of work. And that's our case. That's the individual contract case. In such a case, the question whether the engagement is casual is indeed relevant, but only on the basis that it may shed light on the nature of the relationship while the work in question is being done. So that's stage 3, and he cites Quashie and Windle. So it comes in at that stage. But then he says this. But it is not only legal obligations that may shed light of that kind. If the position were that in practice the putative employee worker was regularly offered and regularly accepted work from the same employer so that he or she worked pretty well continuously, that might weigh in favour of a conclusion that while working, he or she had at least worker status, even if the contract clearly and genuinely provided that there was no legal obligation either way in between the periods of work. The second situation is the continuous unfair dismissal, where you need to show the continuity. The point of showing you this, though, is that to show, one, the relevance of Windle comes in at that third stage. When you're carrying out the balancing exercise, that's where it may be relevant to look at, is there an obligation? Is there an obligation outside the individual engagement? But he goes further and says, but it's not just the obligation. If in practice work is regularly done, regularly offered and regularly accepted, so that they work, that also may go in favour of worker-employee status. And of course we know that that's the facts of that the tribunal found that in our case. In that last paragraph, one of the points they rely on in saying that the pointers to employment is the fact that work was regularly done, and they worked continuously. So I just wanted to pick it up here as we're in Pimlico. Is one, the point of the Windle point is that it comes in at the third stage, RMC third stage. That's the relevance of the absence of obligations outside the individual engagement. But two, as Lord Justice Underhill makes clear, it's not just obligations, it's the practice also at that point becomes relevant.
What, you may be a worker?
Or you see in these paragraphs.
He doesn't say or.
But with
says
respect,
at least a worker.
At least, but if one looks in what earlier in 145, do you see the context is he says putative employee worker? Because in Windle, he's addressing what he said in Windle.
But well, I'm just repeating what you've already asked. But I mean, surely every case, I mean, these can't be hard and fast principles of law.
No,
I mean, what the correct contractual analysis is, because that's what ultimately we're talking about.
Sorry. Yeah. This was a sideline point, though.
I know. It has got to depend on a consideration of the written documents and what their legal effect is, coupled with the way that the working relationship has actually been carried out in practice.
Yes.
And that's essentially a factual exercise, a factual analysis on a case-by-case basis.
But sorry, can I take you to Laing, and then I will come back to that point on the facts, please.
Right, so where do we find
That's
Laing?
tab 49.
49, next volume.
Volume 3, I'm told.
Yeah.
I just want to take you to a few paragraphs of this at a time. So this is another driver case. This is Addison Lee. It is true that the arrangements between the drivers and the company left the drivers with a great deal of leeway as to the time and place where they logged on to work. But it's difficult to suppose that either side engaged in these arrangements in the belief that the other undertook no obligation at all. No honest driver would put the company to the expense of considering his application to join, checking his credentials, training him, and putting him on its system unless he was undertaking to do some work for the company. This is page 719, it's paragraph 63.
I mean, this just illustrates the fact that every case is different, doesn't it? I mean, in the context of what one used to call minicab drivers, I mean, it makes absolute sense. But here we're dealing with, we're a million miles away from that with our referees.
Well, with respect, these referees, the tribunal finds, are refereeing professional football.
Well, of course,
The,
you know that, yes.
The consequences of the referee of there not being a referee for the Saturday is stark in commercial terms.
Yes,
And
that's
the-
not going to happen because of the motivation of all these referees. I mean, experience tests that point, doesn't it? I mean, as far as I know, there's never been a hold-up of the programme of Premier League or Championship League matches because there's no referee available.
But with respect, when one looks at the tribunal's own finding, and if we go to the tribunal's finding at paragraph paragraph 149. 149. Do you see it? They distinguish some of the other cases on the basis that they didn't have an express provision negating an obligation to provide or accept work. In this case, there is. So again, the focus is entirely on that one clause. And they say, PGMOL's regular offers of work is equally explained by the number of matches available and the limited pool of referees on the list. So you've got an express finding of that. And also you've got the tribunal's recording earlier in the decision at page 26. Could I ask you to look at page 26?
But I mean, the commercial motivation or motives are different in our case from here, because the findings of the tribunal were that most if not all of the referees had a job which they did were employed in some other field during the week.
Yep.
And they did this and were prepared to put themselves through this regime because of their enthusiasm on Saturdays, presumably, to be referees. I mean, the Addison Lee position is completely different because, or the plumber position, because that was their only source of income.
But with respect, almost that means it's even more important, because and can I just show you at page 26? Do you see at paragraph 108? When they were reviewing the arrangements, and the tribunal make a finding about this, when they were reviewing these arrangements because they were concerned about status for tax and employment purposes, look what happens. We saw a discussion document produced by Mr. Riley relating to the potential introduction of worker status. This referred to the terms on which PGMOL currently engages with officials and the fact that revised contracts would be needed. It notes that some officials considered that they were PGMOL's employees and discussed possible actions to strengthen PGMOL's position on status, including reviewing the number of officials on each list to create greater diversity in appointments and enable officials to close dates with greater regularity. So this point about the limited pool, and you've got the budget in. They make findings in here about the budget. Of how it's budgeted at the beginning of this season. Paragraph 88, thank you. Paragraph 88, in the 2014-15 budget, PGMOL budgeted for national group referees to referee around 1,600 matches in that season and to act as fourth official in 300 Premier League matches and in 120 Football League matches. Now, so that's the context. And so when one comes to, so that's the factual context, where, as I say, comes back to that
When they go on to say, based on 60 national group referees, this would indicate an average of around 27 matches a season as a referee and 7 as a fourth official.
Yes, and you've got the fact that they, in the next paragraph, over a 42-week season, the average based on the budget looks closer to 4 matches in every 5 weeks as referee, although taking into account FA matches, it may well be higher than that. And again, do you see that in the paragraph above paragraph 88, it talks about the weekly hours commitment. where they accept that when it comes to the hours, they work it out. It's more than 12 hours.
Sorry, which paragraph is that?
That's the 187.
87.
Mm.
Sorry.
But all of that, the FTT don't refer to any of that when they come to consider the construction of the contract.
I'm sure it's a basic principle. We work on the assumption that a judicial tribunal has all its findings in mind at a time when it's dealing with.
But with respect, you've got two inconsistencies here. When you look at that reasoning at 145, it says at 145, when you look at about halfway down,
Yes.
so just below line 35, there is no need for a legal obligation. The referees simply place it on themselves. See the discussion in 104 above. PGMOL has control over the size of the national group and has doubtless tailored that to ensure that in practice it has a sufficient number of referees available and that referees are generally content with the matches that they're offered. Well, how does that fit with the finding in 149 that the regular offers of work is equally explained by the number of matches available and the limited pool of referees on the list? That's 149, and the consultation document that I just took you to that they found. The consultation document that I just took you to, which is. Sorry.
108.
Was that at
108, thank you.
108, yes.
It flatly contradicts what the judge is relying on there. So 108, the judge records that when they're considering how they might change their current arrangements, that they'll need to review the number of officials on each list to create greater diversity in appointments and enable officials to close dates with greater regularity.
Mr. Norbat, it looks as though we're in for another bout of this intolerable noise. So I think what I'm going to do is suggest we rise now and come back at 1:30, and I hope that in the meantime we can get some message out that will stop this intolerable noise, which is really making it impossible for a hearing to be conducted. I'm very sorry about that, but I think if my lord and my lady agree, that's the only sensible thing to do in these circumstances. So on that unsatisfactory note, I'm afraid we will have to adjourn for the time being.
How much longer do you think you can take?
So it's now 12:30. It's
Yeah,
planning to finish by lunch, I think. The noises. We're trying to get back in half an hour, 45 minutes.
So quarter past 12.
So I was trying to finish by lunch, but what's not great is that not only have you got the heat, the combination of the heat and that bang going in your head is, and also trying to listen to what's going on. Not the easiest. Well, maybe it's like a referee, right? That's what you've got going on around you, the crowd. And actually worse, because it's probably personal, what's being said about you. Maybe that is, I don't know.
You can't hear what we're saying.
You stay indoors, which is 5,000.
Yeah. There might change areas in different courtyards, it's just we found one courtyard.
Yeah, it's maybe backbiting the small audiences. Yeah, it's good. Boy.